Okay, so I'm going to be outlining the stages in a criminal trial. There are 12 stages to a criminal trial. The first is going to the trial, or kind of the beginning. This happens after charges are filed. This is where the defendant can choose whether to plead guilty or to plead not guilty. And if they plead not guilty, this leads to the case going into trial. And it just kind of starts the beginning of a formal court to decide whether the defendant is guilty or innocent. After that becomes the discovery proceedings. This is where both sides, the defendant and the prosecutor, kind of exchange evidence. This can be like witness lists, documents, expert opinions, and it just is kind of a way for both sides to prepare their arguments for trial. And then the third stage is motions filed. This is where attorneys can file pretrial motions, such as suppressing evidence or dismissing charges. And then these motions are then reviewed by a judge who rules what is allowed during the trial or what motions will be filed. And then number 4 is opening statements. This is where both sides present like an overview of their kind of side to the story. They present it to the jury. It's not showing evidence quite yet. It's just kind of framing their case to then explain further on in detail. And then the prosecutor's case or the government's case is first after the opening statements. So the prosecution presents their side of the story. They can bring up witnesses, introduce physical evidence, and this is kind of where they are aiming to prove that the defendant is guilty. This kind of leads to the presentation of evidence. Throughout the trial, both sides can present evidence. This can include witness testimonies, documents, physical evidence like objects, videos, things like that. And then the judge's role in this is to ensure that the evidence meets legal standards or just can be reliable in this case. And then after the presentation of evidence, it goes to the defendant's case. This is the defendant's side of the story. This can include the same thing like as the prosecutors, such as calling witnesses, presenting their evidence, or they can even challenge the prosecutor's version of evidence, kind of go back on them. And the defendant in this part is not required to testify or present a case. It can be others proving their side of the case. It doesn't have to be the defendant. And then after that is the government's rebuttal case. So after the defendant rests, the prosecution may present a rebuttal to kind of address things that happened from the defendant's side, maybe specific points that are raised by the defendant's side. It's usually brief and it's kind of focused on clarifying or countering different parts of their case and then providing new evidence to kind of go against that, new evidence or arguments even. And then number 9 is closing arguments. This is kind of like finishing it all up. Both sides summarize what they just talked about in their case. And then they are both trying to get the jury to favor their case so they can kind of reflect on arguments that the other side have made, reflect on points that they made, and just trying to get final statements on their side. And then stage 10 is jury instructions. So the judge gives the jury guidance on how to interpret the law, how to apply it, how to look at the facts that they were presented, how to seek out the truth, and then the judge kind of just gives legal definitions, things like that to help them decide what they think. And then it goes into deliberations. This is when the jury meets privately with one another to kind of discuss the case, discuss what they went over, and then reach a verdict, which is like an endpoint to decide if this defendant is guilty or not guilty. This is where they consider all the evidence that was presented, just kind of everything in the case combining into one to create a final decision. And then last is the verdict. This is what the jury had just decided, and the jury goes back into the court and they present and announce their decision. This is either guilty or not guilty, and then kind of going from there, if it is guilty, this is when sentencing can occur. However, if it's not guilty, the defendant can be released.